indivisible, with liberty and justice for all.
Thank you. All right, up next, we are going to introduce our commission members, starting with my left, please. Jessica Massey, District 6.
Ron Christian, District 3.
Daniel Brzezinski, at large.
Kelsey Crutz, District 5.
Peter Greenberger, District 4.
Hi, Joe Brooks, District 1.
Jennifer Wild, District 2.
Thank you. All right, moving on. We have approval of minutes next, but first I just want to stipulate that we do have a few signed up to speak about items that are not on tonight's agenda. So if you signed up to speak tonight, just remember you cannot speak on the Speedway project. But if you have something else you would like to address with the commission, we will know how you guys to speak tonight, okay? We have approval of our December minutes from 2025. Does anybody have any comments or questions about that? And if not, do I hear a motion? All those in favor?
Aye. That was from our February meeting this year. Anybody have any comments or questions on that?
All the same.
Anybody else? No? Thank you. Anybody else, do I hear a motion?
Motion to approve the minutes as,
Second.
All those in favor?
Aye.
Alright, our last minutes, which are from our February 24th meeting. Any comments or questions about that? Okay.
I will also say.
Jennifer, do you want to-
It was for the RV park and campground.
Oh, is that right?
I was there, sorry. Well, I was there.
February meeting, that's why I was clarifying.
Any other comments?
I make a motion to accept the minutes.
Second.
Okay, all those in favor? Okay, moving on to our next item, which is public comment. So 3 of you have signed up to speak tonight. Starting with Josh Medlin.
I'm going with withdraw.
You're gonna withdraw, okay? And then next, moving on to Tina Howard.
My comments were related to development as it affects North Fish Trap, which I think is still Speedway. So
Is it the Speedway application itself, or is it something separate
it's impact of commercial development coming into North Fish Trap Road
from the Speedway?
from whatever's going in there, which I don't know. I don't know if the Speedway development is coming that far east
Okay.
or not. I don't know how far that development plan is.
then Dr. Steve Jackson.
So mine was similar to that, and at 321 North Fish Track Road, there was a application dated 8/22 for that development, a 99-site home development subdivision. And I'm not sure who has the rights to that, if it's related to the development, if it's continuing as residential, or if it's going to be reconsidered an application as industrial.
That's something separate, so could you please come forward and speak? Hi.
Hi.
All right, tell me what's going on.
So there was an application, 8/22, for development of 99-site home at 321 North Fish Track Road. We got a clearing, and there's infrastructure, looks like it's going in already. The plat that's registered and the planning commission shows 38.4 acres that are being developed directly in front of what looks to be the industrial complex just east of George's Creek, the creek itself with the new bridge. And I'm just curious if that housing development is continued to be housing, as the plat shows, or if it's going to be considered part of a potential industrial area that would flow into North District Road.
Thank you. We won't be able to answer questions on that just now, but if you guys could write that down and then we'll follow up, or it'll get answered throughout the meeting. Okay.
I think the work he's relating to is the deep power substation,
Okay.
because it's 34 acres. So it's not a residential subdivision. It is part of the Speedway industrial park,
With the substation?
but it's the substation under construction.
Okay, all right, well, we'll.
Sounds about right, but staff will get some more information.
Thank you. Okay. All right, well, that closes our public comment section. Thank you, guys. All right, so now we're moving on to our action items for tonight, which were all tabled at our last meeting. So we will have to make a motion, second, and an approval to remove that from the table back to tonight's agenda. So do I hear a motion for that? Yeah, we've got to take them, we have to take them off the table, bring them back into action, so we can discuss.
I make a motion to reconsider, remove from the table and reconsider phase 3. That was tabled at last.
So here's a second.
Second.
Okay, and we're back on the table. Okay, that part, that's important. All right, all those in favor? Aye. Okay.
For the purpose of procedure, should we go ahead and do the remaining phases as well? Or do you want to
That's probably easier.
make a motion to remove from the table and reconsider phase 4? That was stated at last month's meeting.
Second.
All those in favor?
Aye.
One more.
I'd like to make a motion to remove from the table and reconsider phase 5. That was stated at last month's meeting.
Second.
All those in favor?
Aye.
Staff, are we discussing these individually or as a project as a whole?
I would say digitally.
Okay, all right, so we need to start with phase 3, action item 1. So starting with table item LU 260001, commercial development, Speedway multi-use park, phase 3. We have any discussion?
So procedurally, would you like to I guess from my perspective, motion was tabled, or yes, approval was the motion was tabled last month, as a result of, from my perspective, the inability to, properly evaluate whether or not there were impacts related specifically to traffic in the case of phase 3 that were going to be mitigated by SIP. So I think if there are other specific points of impact that we need to be visiting, concerns from folks up here, and the traffic certainly is top of mind to meet. If there are others that we can try to knock them out one by one so that we can have a director. Do that. Okay. I would suggest we have traffic and then what other items we need to discuss.
Anybody else? Comprehensive plan.
One confident?
I'm sorry, can you repeat that?
Comprehensive plan.
Oh.
You've got traffic, and is it alignment with the confident?
Yes.
Specifically, what alignment or misalignment are you looking to address?
I think we're zoned for residential.
The district,
Um,
yes, the district,
So,
with that, that is,
okay, so the concern is that the district is,
it doesn't match our comprehensive plan in which district it should have been. So
so,
that's my concern. And then along with that, comprehensive plan as a guide, if it doesn't match, my concern is if we are to make exceptions to that, that should be done with due diligence and plenty of information and documentation, and I don't think, there's enough with traffic and environmental impact.
You're talking about future land use map.
Why don't we address everybody as a whole? Because I don't know what kind of list you're making over there, but we're in discussion, so we need to discuss the phase 3 itself.
Well, no, I mean, I'm trying to assess what are the concerns, and I'm trying to make sure that I clearly understand what they are. And then, if you don't, I'll restate those if it's not. But I was trying to understand, so I think the future land use in here is gonna be right in this area?
Yeah, and it should be residential.
Residential, yeah, so the concern is that we're in
In public character area.
so the character area is going to be. Is that in staff report?
Yes, it is.
Comments or address the discussion item, if that's appropriate.
What did you say, sir?
Can I address the comprehensive plan discussion item? At the last workshop, at the February 9th planning commission meeting, we did discuss with the planning commission that it's all in the interpretation of the comprehensive plan. Since the parcel does touch 123, the argument can be made that it could be part of the commercial gateway corridor.
But it wasn't in the staff reports originally.
That
in
was
this
brought
application.
to our attention after the staff report went,
Okay,
so,
okay.
by the applicant. So, we made that sort of workshop notice to the planning commission at February 9th planning commission meeting.
But the argument could also be made that it's not. Which is why the staff told us that it wasn't within the application. Okay.
So, do we want to, are there others that we want to capture?
I have no other concerns. I do have comments with respect to the two matters that were just raised, but I'm not sure what the timing is on when I can make those comments. Phase 3 is a limited parcel, correct, that doesn't affect the Speedway. It's outside the boundaries of the Speedway, I believe.
Phase 3 is the retail.
It's the retail section.
there's a portion of it that does encroach on the track structure. I assume you're talking about the track structure.
Oh,
Is that right?
well, I'm just looking at the map. Okay. With respect to the comprehensive plan, we already have approved phases 1 and 2 that are behind us, that are in the same area. So the character of the area is already industrial. So my understanding is the comprehensive plan is not absolutely mandatory.
No, it's not. So it's a guiding document that's approved by the public, our council. We've spent tens of thousands of dollars to evaluate it. Expansion past anything additional that's already there would need support in order for it to match or for it to be considered irrelevant. Thank you.
I just don't see how it's inconsistent with the existing use of the equipment property.
That is completely your discretion. Thank you.
Jennifer, just wanted to your viewpoint on the comprehensive plan.
So we've got different interpretations of what the comprehensive plan. Comprehensive plan is set forth by county council. As I said, we've spent a lot of money on the comprehensive plan. Yes, it is a guiding factor or guiding document. However, with that said, something of this magnitude, in order for us to waive that, oh, okay, well, it doesn't meet the comprehensive plan, let's just go ahead and let it in. Number one, we're setting a precedent for that. That if there's a checkbox by our staff at the county that has at some point said no, and we say, oh, sure, we're gonna go ahead and go against our comprehensive plan, that's a precedent. Now, this isn't a convenience store, it's not a quick trip that we're talking about, and it's not McDonald's that we're talking about. This is massive. So in order for us to even think about going against a comprehensive plan or what might be perceived as a no or a yes, we would need, I would feel, more comfortable with plenty of documentation and information for
What was the comprehensive plan suggestion
residential.
on the racetrack?
I think we're talking,
In
yes,
general.
the whole area, yes.
So the discussion that we had last month was the commercial gateway properties contiguous to 1.3, like touching, phase 3 actually technically is. Phase 4 is not, obviously it's directly above it, it's directly above it. So I think what was presented last month, to the best of my recollection, was that, and Fred, correct me if I'm wrong, but the initial interpretation was that there are some portions of the property that aren't directly contiguous to 1.3. I think the initial take on the map was, yes, this is strictly the residential growth, because it's not a parcel on 1.3, right? But because the entire development is contiguous to 1.3, you could evaluate it as being
Correct.
meeting that commercial gateway corridor.
So our original interpretation from staff was incorrect.
It can be, I would say it can be interpreted either way.
Okay, so then I'll continue what I'm saying. So in order for us to solve the problem of grid participation, I think that we would have to make sure that on our land use attachment A application, we would need information to ensure that it is not adversely affecting the adjacent properties. We would need sufficient documentation studies and so forth for D, which is proposed use will not cause an excessive burden for public facility services, including streets, water, or sewer. So that's my point. That if there is any gray area about this comprehensive plan, we need to make sure that that we are very comfortable that it does not adversely affect according to our land use review. Because we could be setting a precedent, and it's not just a little project, it's significant. That's my point.
Haven't we already had this discussion in the approval of phase 1 and phase 2?
Approval of phase 1 and phase 2 are completely independent of phase 3,
Yeah,
4, and 5, because now you're clearing more land, you're building more property, you're creating more traffic. Those are totally independent. So whether that discussion was had during phase 1 or phase 2, which you and I weren't here for, that is independent. Because the other 3 phases that we're looking at now, they change the landscape, the environment, and the use of that land.
Yes, additive, there's no question about that. But it's still a non-conforming use that was already approved. The basis for approving a non-conforming use.
I don't know, I wasn't here, ask the staff.
Phase 2, that's what I'm asking.
Okay.
I'm asking them.
I think the basis was probably the ordinance described as best I could suss it out. Essentially, the entire parcel is contiguous in some nature to one another. I mean, from my perspective, and again, this is more opinion than it is, commentary on how that was used. If you're gonna have a large parcel, large traffic impact development, probably not have it on the primary. But, to address those concerns, I think phase 3 specifically is contiguous. And would it not be uncomfortable? Would it not be required for us to assess those impacts since this thing is on 123? We would just say, hey, how can I right? And that seems like
I mean, can you say that phase 3 won't cause any kind of excessive burden to the streets?
well, I mean, that's what we're here to evaluate.
Right.
And I think I would prefer that we, I guess for me, the assessing whether or not this thing impacts the surrounding properties is something that we would do outside of whether or not it meets the specific parcel by parcel selection that you do this better. Correct. I mean, you're gonna make that assessment regardless. Correct. But I mean, again, it's not, I am, especially after the conversations we've had with staff on whether or not, you know, how we set character area boundaries and things like that, and the fact that all of this traffic is flowing on the primary arterial for the county. To me, the parcel and the combinations thereof meet that commercial gateway corridor requirement. That was what the land use map, the character area map was there to do, was to drive those higher density, higher traffic flow developments down toward that primary arterial. If they didn't get it right because they didn't know this particular parcel was gonna be purchased by someone else at that time, to me, that doesn't seem particularly problematic.
Okay.
in some regard. I guess first, the dates in here are expired, so explain that to me. How does that work? Was there an extension
Yeah.
filed?
2 years.
You have 2 years from the date of the agreement,
Okay.
So it's no longer binding?
So, but,
because it was signed in 2025, I believe.
June 25, June 9th, 2025.
so you guys started reviewing the project in 23 with the Army Corps, we shouldn't sign it until 25, so it's still in compliance? Okay, so no expirations here? Cool.
I think there's also an extension that can be requested.
Okay. The Sunshine Speedway project that you guys kind of have modeled here, that's what you're using the basis to do your Memorial Drive, correct?
The Sunshine Speedway was an example of a racetrack that had been redeveloped in another site, in another state.
Right.
And the requirement from that historic preservation office and the Army Corps of Engineers for that site required a website to be written up by a historian that documented the history of the track. We included that to show just what examples of other sites that have had similar situations happen.
So you copied in a racetrack that was saved?
No, that racetrack was redeveloped.
No, so the only thing that was done with that was the website was created with historical information and detailing.
That's correct.
A contrast to what you're proposing to do here, which is create a Memorial Drive and put the monuments in there with the drivers' names and then various other pieces of information.
But when you look up the Sunshine Speedway, it's still an existing track that's in use. It's just been renamed.
I'll take that.
Uh-oh.
Alright, I just wanna make sure, because my research showcased that it's just been renamed.
Well, regardless, an agreement was made that that mitigation could be done if it were to be redeveloped.
Okay.
But the entities that have the expertise to make determinations with respect to historical significance, the Corps of Engineers and the state historic preservation officer have entered into an agreement that prescribes certain mitigation criteria, which if I understand it, the applicant would employ if authorized to proceed with the project. Right.
So why, I guess kind of explain to me how you guys reached this agreement with the Historic Preservation Office, et cetera. Like the mitigation to me seems a little light, like how did this all kind of come about? Paint me a better picture here.
I've made a suggestion.
Okay.
I mean, I'm open for suggestions from anybody. I don't know how you memorialize a racetrack, you know, better than what racetracks have been, honestly. So I actually took that concept from, you ever been to the Dallas Cowboy training facility called the Star? And all their Hall of Fame players have that same monument throughout their cityscape. So I thought it was kind of cool, it looked good, and that's why I suggested it.
So,
I'm not real smart, but still ideas for other people.
idea of just preserving the track itself, and we've got to circle back to some of this information because I forget. It was because it was, what, not worth preserving, like it just didn't make sense with the concept you guys are proposing. I guess I'm trying to get to the root of, this document tells me that this is a historic monument, the site itself, the racetrack, that it's eligible to be a historic monument. The mitigation being proposed is just a Hall of Fame lane. How did we get from we decided not to preserve the racetrack, even though it's eligible to be a historic monument, and shifted gears to just making some sort of drive-by memorial. Like, why?
Well, the track's not functioning, and it's going to continue to deteriorate unless someone purchases it.
Okay.
And we've had, even as of an hour ago, conversations of selling the track. We do have one potential buyer. Jackie Manley's here. We met February 20th on track. Myself, Stan, Jackie, you, Rex Rice, and maybe that was it. We agreed to some terms and conditions. That was a Friday. Tuesday, I sent a purchase contract out for his review. That was February 24th, 4 days later. But you had 2 weekends. March 4th, I received Jackie's comments back. March 5th, 1 day later, I revised the contract and sent it back out. March 6th, I was told an email from Jackie that the contract was agreed to and was ready for execution.
Repeat that date.
By Jackie on an email March 6th, which was this past Friday. The contract was agreed to and ready for execution. We put it in final form, sent it out with DocuSign, and here we are. I did not get it back. I called Jackie 2 or 3 times today, asked him if he wanted to sign the contract. So, I think there is there's one correction that's got to be done on the acreage. They doesn't quite match the exhibit, but it was never being sold on a per acre price anyway. This is what the track is. And then there's some clarification on security of the track that needs to be worked out. So we can sign it right here, right now.
So you're still kind of negotiating.
We've agreed what he says.
You've agreed.
Contract in final form was 2 changes.
Okay, I don't want to get too deep into the contract talk, but I do want to just clarify a couple things, because I do think it's important to the track itself, because if it is going to be sold, then that changes the entire reason we're sitting here, right? So is Jackie, do you mind if everybody's comfortable?
I'm not sure I understand how this works in this sort of conversation.
Well, it does, because if somebody's purchasing it, and it's still eligible to be historic, and we're up here voting on its land use, then we need to understand, are they in agreement to buy a racetrack right now, and we still need to give them land use, or?
So what we are here to evaluate is whether or not the significance of the site would be adversely impacted on the land use that we're here to approve. Right? We're not saying whether or not the proposed land use would even go forward necessarily, right? But we are looking at whether or not the State Office of Historical Preservation has said this mitigation provided by the applicant is sufficient in their opinion. So we are looking, from my perspective, at whether or not we would overrule the State Office of Historical Preservation by saying, you know what, that mitigation is not acceptable, and the historic significance of this site is of more value to the community than the State Office of Historical Preservation has assigned.
Yeah, Trent, that's what I'm getting at. So can I finish asking my question about the offer that's being presented?
Why is the purchase relevant?
The purchase is relevant because if somebody else is purchasing the racetrack, then why are we reviewing land use?
The land use is moving forward.
Then we need to know if there's a purchase going through, which is the question that I'm about to ask the guy who has an offer in.
I'm comfortable.
Sure.
Jack,
Yes, ma'am.
thank you. Sorry. Where are you at in your offer?
The attorney's going through everything. We sent it back with our revisions that need to be done, and when he sent it back, like he said, he sent it back, nothing was changed on it, just sent it back, and he did call today, and I told him the multiple things that was changed, it has an exhibit of the property, like you see there, that says so many acres, and then at the top where it says, you're purchasing this many acres, it was two different numbers. So the attorney had a problem with that, and there was 6 items that need to be addressed on it, whether it be completely changed or reworded. Some of the things was reworded, we'd be fine with, but some of it need to be took completely out. And when he sent it over today, like he was talking about, it's one item was all that was changed. So he kind of didn't give no time. He talked to me right out there in the park or in the hallway, didn't give time to really, the attorney to go through it. And like I told him, it's a safety thing for us, just like a safety thing for him. So he just didn't give us the time to get it back to him.
Okay, so we're all in agreement that negotiations are still being made to purchase the racetrack.
I don't go, the written documents I got in my hand, that it was approved Friday for signature, didn't get signed. I called them today, there was a couple issues, we corrected that.
No, you didn't.
Even I knew there were 2 issues that I just mentioned.
So it sounds like there's still a
Two
good
of them
faith.
was right those, one is typo, one is a misunderstanding that needs clarification.
Okay.
Only thing I'm asking for is the security on the track while the event's going on. I think that's a reasonable request.
Well, I'm not gonna get into what's reasonable, what's not
Well,
reasonable, Mr. Ross, but it sounds like there's still a good faith effort here
He interpreted.
that you guys are negotiating contract.
There's going to be security for the entire park. Not what's the intention of all of these boards. I think the main thing, I don't know anything else that needs to be corrected.
Okay, so again, there is still some sort of good faith effort between both parties that you're negotiating the contract with Speedway. And you can't tell me that there's not, because the man just said you guys are speaking in the hallway about it.
That's right.
Okay, all right, that's all I needed to know. Thank you.
Can I ask a question since we've got him?
Please.
Is there a binding commitment from the lender for the purchase price?
Yes, sir. And he's got it also.
And would it be your plan to rehabilitate the track so it's operable?
Yes, sir.
And you have the capital necessary to do that as well?
Yes, sir.
The commitment I saw was for $2 million of a $4 million purchase price. The $4 million purchase price doesn't include all the things it's gonna take to make it operational. I've not seen any term sheet or commitment letter for the entire project.
But if you need the approval letter, I can show you it however you want it. He's got the approval letter too.
Thank you, Jack.
And just like any other loan, the approval letters for so much, you pay the down payment, it's done.
Yeah, just one quick question for the seller. So just to be completely clear, as I understand it, the differences that you have at this point in time are primarily technical issues that need to be resolved with some adjustments to the language or the actual acreage specified, et cetera. Is that a fair characterization?
In relation to the purchase contract, you're 100% correct. It's a couple of things that just need to be tweaked. As far as showing the ability to close, I have not seen anything that made me feel like a closure.
Okay, but
What I would respectfully ask is the plan get approved, if he shows the ability to close, and the Very good at that.
One of your concerns about the contract is that there's nothing going on in the contract for survey.
Did you put the front back in the entertainment? That was, so, they do it, so, yes,
So just a quick, couple of questions about this. In the kind of lower left corner there, this is parking for the track, is that correct?
no, I was, what's inside this is between the,
Okay.
these are two outdoors, and that's not.
Okay.
Remember, I'm saying, to take her all the road, so, essentially, I'm buying these outdoors, so we have these.
All right. Okay.
So those are street commercials, so, yes, sir.
So you're telling me that if the purchase goes through, this is now the plan?
This would be, if he purchased, this would be the plan that's agreed to.
So then, let me ask staff from that perspective, if they're changing their land use due to the sale of the track, then they would have to resubmit and go through this process all over again, because it's a change to their application.
It's a modification to the siding plan.
So yes. Okay.
Madam Chair, what we're asking is that you approve what we're asking, from our opinion, you approve the plan as we've offered, presented tonight.
Okay.
If Mr. Manley signs the contract, get on the contract, and he can close, and he would come in and resubmit to you to put his plan. But if he doesn't, then we would be able to move forward with the plan as we
There's
presented.
two elements in this plan that would not be his property, it's your property. They're the two that we just talked about, on the corners. So those would be material changes to the application you have now.
No, we're asking you to approve our plan the way we've offered.
You're asking.
No, I
us to-
understand that, but you said that the purchaser could later come in and submit for approval for their use, but there's two elements in this that you would have to submit for, and also that would involve a change to the plan.
If we would agree
Right,
with that.
and which staff has just advised us that that would require a resubmit.
We're agreeing to work,
resubmit.
to
So you're-
resubmit if that's the case, if he gets to that point.
Well, then what are you asking us to approve tonight? Because what we have tonight, which is what is on the
Yeah.
screen,
Yes.
is different than what you're.
That's right,
telling
so
me
we're asking you to
here.
approve this,
Okay.
and what you're looking, what we have in front of you, what we brought you last meeting.
Mhm.
And then, Mr. Manley purchased, so if he purchased the contract, we can all resubmit and fix it to make it work as you got it in. But if he doesn't go forward, we don't all have to come back out here.
They'll tear it down tomorrow as soon as they get
I
approval.
understand.
Yep, they'll tear it down tomorrow. Tear it down tomorrow. Yep.
Phases 4 and 5 would be separate, correct?
Yeah.
They're not affected by this.
These,
May I ask the staff a question about the comprehensive plan? If this gentleman is successful and acquires the track and hasn't been on it for years, for purposes of the comprehensive plan, we heard it's residential area. Is it a matter that they would have to be reviewed under the comprehensive plan in order to determine whether resumption of race operations could occur?
that residential growth area.
But the track preceded the adoption of.
There's my overlay district.
But it hasn't been operated as a track for a number of.
There's my overlay district.
Start the clock with respect to whether or not.
It's not called spot zoning, it's called an overlay district.
Continued as that use. It hasn't been used as a racetrack, it's been discontinued. So therefore, if it came back before you, if it still says that that area is a residential growth, that's what we will put in the staff report, is that that falls into the residential growth area.
So the same issue as we see with respect to the proposal in phase 3.
And remember, a racetrack is a use which requires planning commission approval. A racetrack requires commission approval.
This racetrack does? It lost its racetrack use, so yes, it would have to go back before you.
It's a separate and distinct use,
Yes.
so it requires a specific approval.
So when do we start working on the next comprehensive plan? We're coming up on it real quick. That'll be next year. Sure. So in fiscal year 27, I believe we're gonna, submit request for bids by end of this year, and then next year is whenever the updates.
Okay, so our comprehensive plan based on our growth in Pickens County may change
It most
within
likely
the
will.
next 12 months.
It most likely.
Okay.
So if the track is purchased and it's operational, then, understanding what you're saying here, it needs to come back before us for land use. How is it not grandfathered in, considering its structure is a racetrack?
The use closed, and so if it's not an existing use as that use, then it is not a pre-existing non-conforming structure. It has to.
So the fact that it hasn't been in use for the past 12 years or whatever.
3 years.
Three.
3 years.
Yeah.
Is that correct, 3?
3.
Yes,
3.
Yep, 3.
So I'm assuming your contract has a condition to closing, that you have planning commission approval to operate it. Contract is, 60 days ago, that's in 45 days.
I don't mind contract questions, any other contract
No,
questions?
no.
Okay. Alright, so circling back to our MOA that we're having discussions on. I still have questions regarding, and maybe this is just more discussion amongst ourselves, because I
information that they had satisfied the concern with respect to the historical designation by going to the bodies with authority over those matters, and they reached an agreement with them. And I feel like if we sort of treated the trade, if we sought to offer incremental conditions on the agreement they struck with the state and with the federal government, I mean, that's just my own assessment.
Any other discussion on NI? So moving back to the traffic study.
We also have our traffic control, which we have these questions.
Thank you, Mr. Wilson. Anybody want to start on that?
So, in reading the traffic studies that were presented, appreciate the fact that they were submitted in between this meeting and last. It strikes me that each one of these phases was considered individually. And I don't get a sense from the studies that we have that the site plan has incorporated the requirements of each of the individual studies. In other words, there is suggestion within, I think it's the phase 4 traffic study, that there be additional entrances provided on Fish Trap, and then connector road that's brought down to 123, the entrance on 124 moved westward a few hundred feet, if I remember correctly. But I'm not, I didn't, and maybe do we have that as a part of the site plan? Because like just the phase 3 site plan doesn't seem to show that.
And what are you looking for?
I'm looking for something, there's some conceptual diagrams, the one that strikes me as being the most impactful was this is figure 17 from, I believe this is the phase 3 study, which has multiple entrances. There's a red light on Fish Trap in 123, and then what appear to be 3 separate entrances from Fish Trap, one to the south site and two to the north site. And then a stoplight on 124. I'm not seeing all of that consideration in the overall site plan. So I get what concerns me, I think, is that there have been some pretty detailed recommendations made regarding traffic and flow for each one of the individual phases. But I don't see the overall site plan as having incorporated all of those. Is that true, or were they, as the nature of the site plans progressed as a phase, did we incorporate them individually? Because it would seem hard to sew the whole plan together that way.
Yeah, great question. You can help me. Sure. I'll do my best as the non-traffic engineer. So figure 17 is contemplating phases 3 and phase 4. Phase 5 was its own separate traffic study.
Yep.
Okay, so the furthest left street light, I notice we can't see 2 plans at once, but that is the proposed signal that would be the main entrance to the park with the monuments.
Okay.
The signal further to the east is the realignment of Highway 124 with Highway 123, part of the application project. The signal on Fish Trap in 124 is existing.
Yep.
Access A is existing. That's into the park that circles around the racetrack. So, what explains it the best is there's a 4-page memo that we provided, that updates the phase 3 and phase 4 site plans. The traffic counts actually got a little bit better.
There's all the traffic count updates, what I didn't see was the site plan updates. That's what we.
There were attachments to them. I don't know if that was included in the packet.
In your packet, or you gave it to staff?
The memo that I put together had the 2 site plans that I put
traffic study, which is phase 2.
So,
It's not labeled or anything, it can be, like you see this here. There's no labeling or anything like that. This.
I'm looking at, I think this must be, this is labeled Greenville Pickens Flex.
That's phase 5.
That's phase 5. So that considers, if you're able to pull up the one that's Greenville Pickens Speedway Flex, I think it's page 21.
I believe what he's saying is that this is phase 1.
Yes, it is. So I'm trying to get at why it doesn't, I don't see consideration for the project as a whole. I see phase 5, phase 3, and phase 4.
The big project, what's being built now and what they're proposing in phase 3 and 4 were included as, what we call like an adjacent development, like background traffic, as if they'd already been approved.
For the traffic count perspective, like.
Yeah, and so phase 5 was analyzed with that traffic in the background.
Okay, so this then is the 2029 post-build with mitigation plan. This should incorporate all of that traffic count data and recommendations. So the overall site plan should look like this.
Phase 5, section.
Includes phase 5.
This is only phase 5.
This is just phase 5. The south side is between 124 and 123. The north side is east of Georges Creek, north of Highway 124. But one of the developments to the west of Georges Creek is shown on the picture. But it incorporates it in background traffic.
Okay, so it's a global analysis that was done to incorporate the first two, which are already in progress, and then everything else is rolled in on the other side. So the infrastructure doesn't necessarily connect to each other, but they are part of a singular global analysis.
East and west side are not connected.
Right.
I mean, they're adjacent, but it's a global analysis of all of the development happening. So it's
Sure.
it's
But already it's changed, which affects traffic.
Is it a worst case scenario?
It is that the analysis done in this study incorporates phase 1, 2, 3, 4, and 5.
That's what I was trying to say. Thank you.
So that, and the reason why I'm asking is because we specifically tabled a motion for phase 5 last month because of impacts to traffic at 124 and 123, but also specifically due to concerns on access on Fish Trap. And there was a little bit of concern at that time that there might not even be access on Fish Trap. And what I see now is 3. This is phase 5, so we can hold that for phase 5. But my concern is the same with both 3, 4, and 5, in that I can't, like the 124 reline. There is nothing in this packet that describes to me what that 124 reline is going to look like.
Isn't this
We've had that in our previous packets, so you're correct, it's not in that traffic
There's
study
a
analysis.
relation one.
It's, I mean, the site plan is the realignment.
There one more figure.
The site plan for phase 5 has that in there.
With the red arrows. So the
understand the traffic counts, and this is, from my perspective, this is not a site plan.
No.
Okay, all right, so we're agreed on that. So what I didn't see was the site plan incorporating that realignment plus, and I do see accesses to and from fish trap, and provided that DOT's reviewed that, I'm not gonna say that we did or didn't. That seems reasonable, right? It seems like we made adequate consideration for that. My understanding was that the 123, 124 interchange realignment was a part of the package that was gonna be submitted to us. I don't see that one here.
You're talking about the roadway plans?
The road, the site plan itself, yes.
Remind me how specific we were in the language when you asked for a traffic study? Did you ask for that to be included?
Yeah, we tabled it because we couldn't probably assess the impact of traffic.
The motion was, one second. It was, I wanna say it was traffic study and any, hold on, that's phase,
Any changes to the site plan based on addressing this?
that's for phase 5. Phase 3 and 4 was tabled with the motion, due to additional information needed, including a traffic study / supporting material. So any additional information, but traffic study, additional information.
And then when we left that meeting, when I told you guys we would stay, I suggested that they go by our traffic study policy and to add to your traffic study concerns, that would have generated the 2-mile study, or it should have, based off the trip count.
So, do we have, sorry to make you do the homework here, or the hard work, do we have a phase 5 site plan that we looked at last? Because I wanna make sure that it's good.
Not one with a residential.
So, this is an overlay that describes the proposed use. It does have entrance and exits, more or less, meet the description that was presented. Where is the 124, 123 intersection realignment described there? So that kind of, yeah.
You know, there was another map that you guys presented that had the realignment in it.
The phase 3 is a little more changing than easier to see the realignment.
Okay, can we go to phase 3 for a minute? No, that's not it either. You guys have submitted something else along the way that showcased 123 and 124 alignment. Maybe it was a DOT sketch or something else, but it's not in this packet. It was a separate document that showcased the changes.
It is, let's see.
Do you guys remember that being submitted?
Well, as far as,
I remember when submitting the concept, but if I recall correctly, there was a discussion that the actual measurements and details, which will be determined by the engineer.
right.
So we got the 2-mile thing then, the 2-mile study? Because I didn't see that as one either.
No, it wasn't.
The extent of this abuse of funds, for sure.
What was that?
I said, it does not appear to be,
No, it's not. It's just immediate intersections. When you guys look at the traffic study policy, was it something that you couldn't, thank you, was it something that you couldn't produce with the 2-mile study based off of our traffic study policy? Was it something that wasn't discussed?
It was more so based on, we had numerous calls with the Department of Transportation 2 years ago, and they said,
should have figured trips and days generated were greater than 1,250, which would have signaled the 2-mile traffic study. And if you didn't think that, then why didn't we have a conversation about it?
Well, I think one part of that policy is to study the origin and destination as well, is that correct? So are we supposed to study the 27,000 vehicles that were about 123 every day? And figure out
What
where
do you
they
think
came
about
from?
that?
Where they start, where they go, where they start, where they go.
Okay, well, you can do the best to your ability what you want to do with that particular standpoint, but the rest of it, you think that just negates the 2-mile study because you can't produce that tidbit of information?
Well,
Because you're gonna have to do it regardless, so.
I wouldn't say it's a tidbit, and if we need to provide that, then we can provide that. If it was not possible in the time frame that we got.
That's the issue.
And that's understandable, I understand that.
Timing's a big one.
Okay. Did we all hear the timing issue and the 2-mile study answers? And understanding of that? All right, Mr. Trafford now, bring on, what's next?
That actually addresses my concerns. I see where DOT has reviewed the traffic counts, DOT provided an input with the extent of the study, and they met the requirements that they had agreed on, as to satisfying the requirements that would have been provided through, county limits. I agree.
Any other discussion on traffic?
Just a question for the staff. There is a person within the county government that also reviews these matters? And where is that?
The county engineer will review these documents.
Is that done preceding approval or
That's
subsequent to
done
approval?
post-land use approval in the development review phase.
That was interesting.
All right, so moving on to kind of some of the concepts of our capabilities of asking for traffic studies and site plan issues and et cetera, which is all stated in section 12 of our UDSO. So I want to just kind of outline a couple things and then kind of tie that back into where we're at. So Article 12 gives the commission both the authority and the responsibility to review land use applications and determine whether they meet the standards established in our ordinances, right? Section 1205 states that certain uses of properties and structures requiring planning commission approval and that no land use approval becomes effective unless it's first submitted to the planning commission for review and approval. So we're not a ceremonial body, we are the decision maker, and we are responsible for evaluating whether an application meets ordinance standards or not. Section 1205 also states and establishes the process for making that decision. So before taking the final action, the commission must hold a public hearing, which is what we're doing, receive staff report, hear from proponents, opponents, ask questions, and make a decision. Under section 1205E, the commission may approve with conditions, deny, or allow for withdrawal, or table the motion to the next scheduled meeting. So we have all that in our purview. Section 1205F lays out the objective criteria the commission must consider when deciding whether to approve land use request. The commission must determine whether the proposed use is consistent with the surrounding area, whether it may adversely affect nearby property, whether it's compatible with the comprehensive plan, and whether it will create an excessive or burden to the use and public facilities around it, including streets, water, sewer, and emergency services. So just keep in mind, when we're bringing in taxpayer dollars, that those things are already divided up amongst those services. Section 1205I goes further by giving the planning commission authority to impose conditions of approval where necessary. So that includes right of way,
parking and loading areas, driveway and access locations, landscaping, buffering requirements, preservation of vegetation, et cetera, et cetera. The ordinance also makes clear that land use approval and development permitting are separate steps. So under section 1207, the planning department must approve a site plan before development permits or land use activity begins. So yeah, we review these preliminary plats and then it goes to staff. Section 1209 further states that no development permit may be issued unless the planning department has determined that the proposal complies with all the requirements of the development ordinance. If a permit is issued in error or contrary to the ordinance, it's considered null and void. So, in other words, the commission is not being asked to blindly approve a project and trust that the details will sort themselves out later. These ordinances require compliance at every stage, and the planning commission has the authority to make those decisions. So when we kind of get into these questions of, well, it can just go to the next department and they can figure it out from there, or strictly land use, that's not what section 12 says.
I don't think anybody intends that.
Well, I think we do.
Yeah, I think we do.
Who intends that?
Who intends that we're just land use?
That we just pass this on. I mean, we do expect the trained professionals to do their job within the county, but I don't think we believe they're thinking we just got the whole county.
But that's the impression that we're giving when we say, okay, well,
But we're,
that goes to the
we're a
next
volunteer,
department.
we're a volunteer commission. We're not trained engineers, we're not traffic study people. We're here looking at land use.
And we're here evaluating the ordinances and how they apply to the application. And if they do not meet the ordinances, then we don't approve projects, or we make conditions upon approval. There seems to be the stipulation of, okay, well, we don't have the authority to make these decisions, and I want to make it very clear to this entire board, because we sit here every month having these exact same conversations about what our authority is, that we do have the authority to use this UPSO, and people who are doing business in Pickens County have to comply with that. And it really irritates me when we ask for a 2-mile traffic study and we don't get one. We've already had a traffic study come in on a previous application that stipulates that almost every intersection on 123, we are failing. This is like a 2 million square foot complex that we're bringing into our county. To sit here and say we don't have to carefully review this, not okay with me.
Well, I certainly didn't say we don't have to carefully review it. I'm simply trying to understand the process. I agree with Dan. I'm not a traffic study expert. I mean, I read this document, but frankly, it was not very meaningful to me because I don't have the expertise to understand it. And I feel like I have to rely upon the technical staff to give us their best recommendation with respect to whether or not we should find it to be acceptable. And I simply ask, what is that process? And as I understand it, the technical expert within the county, which is we're dealing with county matters here, hasn't yet had the opportunity to review it.
Correct.
And so that's where we are, and I'm left without the recommendation of an expert.
May I? I think when there is a lot of debate, I think when there is a lot of gray, I think when there's not a lot of precedent in place, it is our duty as an appointed Pickens County body to ensure that we gather as much information as possible. And no, we may not know the ins and outs and the details, but we're also, Pickens County has done a really good job, I think, of putting some pretty smart people on this planning commission. And I've said this in the past, when we just consider, well, we don't need that information because somebody else will look at it later, we are setting up our county to waste resources, time, other departments' time, etc. And there have been cases where I have myself argued against approval of things, but there's been gray. And then we could get down the line after so many, paid hours by our county staff and our county experts where our gut was right. All we needed to do was ask for a little bit more information, and it probably would have been clear to everyone. And so I think that whether or not we're the experts or not the experts, we have the authority to ask for that information and base our decisions on that according to our land use.
The only thing I've heard tonight that sounds like it's explicitly not in compliance with the ordinance is the lack of a 2-month study. Everything else is a question of judgment. Did the historical preservation mitigation meet what we think is appropriate? Is it inconsistent with the comprehensive plan? Does it comply with the section of the comprehensive plan because it's contiguous to 123?
I agree with exactly.
And also the timeline. It needs to be done in a 20-year timeline.
I mean, there's probably a couple of things I could dissect in the site plan, but you guys are just gonna tell me that that's preliminary and it'll get worked out with staff, so I'm not even gonna go down that with buffers and rewalk easements and et cetera, even though there were things on the site plan that were not in compliance with what they're going to be able to move forward with. So there are other things that we could sit here and dissect all night long, but if we wanna just stop at traffic, that's fine as well. Does that conclude our discussion? Please. Yeah.
If there are other questions about other items, it would benefit us if we could know what the concerns are so we could address them in the future if necessary.
Okay. Well, we might have to move on to phase 4 next to kind of get into those discussions. I guess I could go ahead and bring them up now. My question on the Rewa sewer easement is, have you guys spoken with anybody?
Move on, let me withdraw the motion from the table.
Okay.
Then we're going to proceed to having the next item on the agenda.
Well, it depends on how, if my question can be answered first, because we've kind of been we've been bouncing back and forth between a couple of these projects, so, what are you wanting to propose?
The motion on the table currently is to approve, there was a second, with some discussion. If we are going to discuss the next phase, it's fine, Jimmy, I would like to withdraw the motion on the table.
So you can talk about phases 4 and 5 with a traffic study, but I can't ask a question because it's in relation to phase 4.
I'm not suggesting that, I'm just suggesting that the motion on the table was that we approve phase 3, and we were having that discussion. If it's related to approval of phase 3, that seems like continuance of this discussion. It sounded like we were I'm simply trying to help make sure we keep track of the procedural part of it.
Yeah, that's fine. I think I can get through this question pretty quick, and it kind of ties into phase 3 anyway. So it's on the phase 3 site plan, so I'll just continue the question if you don't mind. Okay. The Rewa sewer easement, did you speak to anybody from Rewa about their easement, and how does that comply with what you guys are doing with your project?
The only phase that is adjacent to the Rewa easement is on the east side of Bird Street, which would be phase 5. Is that what we're talking about?
It could be, it's still showcased in your site plan for phase 3 too, so you're gonna have to kind of help me understand it.
Okay, So, you probably know this, but the rebar easement runs along the east side of Georgia Street, and then crosses under Highway 124,
Okay,
and then crosses under Highway 123, and then terminates into treatment plant.
okay.
Downstream. Everything that we're showing on phase 5 that is near that does not encroach into the rebar easement.
Okay. So on your site plan here where it has, what is this red line crossing over into the wetlands and the easements?
The red line is the existing road that circles around the racetrack.
No, there's another red line that goes right up the creek.
Oh, that's a property line.
That's a parcel boundary.
That's a parcel boundary, it's the center line of that creek.
Okay, all right, thanks. And then sure, you can continue with your motion, I'll move on to my stuff for the next couple of phases.
So you'd like for me to make a motion for all?
You said that you had something you wanted to present.
I was simply stating that if we wanted to consider, what I felt like was moving on to phase 4 consideration, then we needed to withdraw the motion on the table for phase 3. If we're ready to vote on the motion that we have on the table right now, whatever seems, wherever you'd like to steer the discussion.
So you don't want to withdraw your motion any longer?
If you are not continuing discussion on phase 4, I would suggest that we act on the motion that's on the table now.
Those two things are related.
Well, perhaps what I can do then is withdraw a motion to approve phase 2. Sorry, phase 3, and we need a vote for that. And then I'll submit perhaps that we put a motion on the table later to consider both phase 3 and phase 4 at the same time.
That works for me. Thank you.
I'd like to withdraw the motion that's on the table currently to approve phase 3.
Second.
All those in favor?
Could I put a motion on the table then to approve both phase 3 and phase 4?
Second.
All those in favor?
No. The motion was to approve,
Oh,
so I think we want to have the discussion right now, right? Is that correct?
Well, we're moving on to adding phase 4 in it, so we don't have to make a vote to combine the two.
And the vote is to combine these.
Did you catch that, Sydney? So we withdrew, and then you voted. Correct. And then Tripp made a motion to approve phases 3 and 4. You then voted.
We made a motion to combine them for consideration,
for discussion.
not to approve.
He said a motion to approve phases 3 and 4. Then Daniel seconded, and then you voted. Okay, well, then we need to retract that.
That's not what we did the first time.
You, at the beginning, all you did was voted, and then you had a second, so then you discussed, you never voted at the beginning. Now you voted to approve phases 3. Okay, so can we continue with our discussion without recognizing the vote? I think that's a motion to approve and you voted. That was not.
No, that was. He just tried to pull one over.
No.
Yeah, he
No,
did.
he said no.
Like clearly they were just talking about that.
Yeah, and also, this just, I'm about to take us down something. I would like to see us begin to do roll calls to make it very clear, yes or no's and votes. That's typical in planning commission voting, is you make a motion, everybody votes with their hands, and then the roll call goes down the count.
That's up to them. That's
Okay.
not up to staff.
Okay, okay, so.
I do not know the proper procedures
phases 3 and 4.
Right.
Okay, good. Then let's move on to discussion. Any discussions on phase 4 now? Nobody else?
Could you put the phase 4 map, or,
The only thing that I would say related to the discussion we had on the phase 3 part is the use is light tourism. Right? So it's not the retail gas station, this is light industrial. That changes the perception of how it's going. Because now it's under my consideration personally, but that's. I believe concerns related to traffic have to be addressed. During the discussion we had. I don't know this
I may have missed it, but is there a timeline for how long it would take the racetrack to become operational again? Do they, has that been discussed?
I'm gonna interject, so y'all voted, so you can make a motion to reconsider,
But my question is,
and then undo it.
the chair did not say all in favor, and then we all said aye. The vote was not complete, period. The chair must say all in favor, and everybody must say aye. That is the closure of a vote.
I think procedurally, for clarification purposes, it would be beneficial to go ahead and do the reconsideration because it was unclear, and then y'all can all just clear the slate and keep going.
I would make a motion to reconsider and rescind the earlier vote with respect to phases 3 and 4.
Second.
Can I say all those in favor?
Aye.
it matter?
Thank you. Still on the table, guys, we're good.
So for, in, absolute. I can't take it. I am going to make a motion to approve those phases 3 and 4. I would like to have a second so that we can have the discussion on the 2 projects. I would like to make a motion to approve both phases 3 and 4 concurrently.
No, that's what just got us into this mess. You can make a motion to discuss 3 and 4 combined.
So your discussion is after a motion, then you second, you don't vote yet, you just second, and then that opens discussion.
You originally tabled 3 motions. I would advise that you take this motion as individual. Three were tabled.
So you're advising perhaps go back to 3.
3 motions were originally tabled.
Okay.
3 motions were taken off the table. There are 3 land use proposals.
Okay.
So you're asking to reverse this withdrawal?
I'm just simply stating that I think for matters of simplicity, it would be easier to consider your motions one at a time. Cover each proposal, each land use proposal, each motion that was originally tabled.
Last part of my night, guys. I guess you're being asked to reverse your withdrawal.
Yeah, I mean, the motion to consider phase 3 is really, this one, on the table.
You're right, I'm sorry.
No, that's what I was thinking.
Let's just continue with discussion and maybe we can circle back to procedures if we need to. So we're currently discussing phase 4. Trip has no concerns because his traffic questions have been answered. This is the parcel that will be built on top of the racetrack. Are there any questions about this parcel?
If, catch me up, is there any kind of body of water that is running close to that or under it?
Yes.
Yes.
Yes, there is.
Okay, so my next question is,
That was discussed 30 days ago,
okay,
and we had our engineer here,
right,
and it's not a major problem.
what wasn't a major problem?
There's a small creek that runs through that property,
So it wasn't a major problem for flooding,
not a problem to deal with.
not a problem to build. So what about the demolition of an old site? And how that might affect the water and any kind of runoff, construction runoff,
It wouldn't affect it.
Lead-based paint.
it wouldn't affect it. Because my concern is, back in my heyday, I worked for, historic preservation for the Charleston Museum. And we had some pretty strict guidelines when there was any kind of demolition of a site that was, I believe it was 1980, that was older than 1980, because of the contamination of different building materials to the land. I think,
Asbestos or
yes.
lead?
So my concern is if that gets into the water table at all, how, is there gonna be a certain, are you all going to test to see if that material has any kind of toxic or before demolition?
Yes, the answer is yes. In order to get a demolition permit from the county, if there's suspected asbestos or lead in any structures, we have to test for a permit issued to us. And I believe that permit is issued by DES.
It is, so Kyle sent us a response from, DES, and, they basically said that they would have to look, inspect it, just to make sure that it meets, everything's good with them before they could move on with demolishing.
Okay,
But that's DES.
okay. So that would, they would get a permit, they would test, you guys would test it, and then get a permit. What if they don't pass the permit, what happens? Would you try to sell the land again as a racetrack? Because you couldn't demolition?
Generally speaking, there's always a way to demolish a building safely. It just might require
A lot more money.
a lot more money or measures to do that.
Yeah, yeah. Well, that site is pretty old, so I'm just saying from a perspective of literally I've helped preserve homes in South Carolina. You might have yourself a money pit there to demo it. That's all I'm gonna ask.
Circling back to the MOA, favorite topic tonight, building 7, or structure 7, was considered a contributing resource to, I guess, the historical significance of the track. Correct me if I'm wrong, but building 7 is the concession stand that was torn down on the track?
I don't have 37 from, I'm sorry, I can't recall.
Demolish a structure that was a part of your agreement with the Historic Preservation Office. Does that change your agreement with them in any way?
It was not intentional. I don't
Yes, it was. Liar.
A tractor is not intentional?
A concession stand is not intentional?
So again, it wasn't intentional, but we did. Right, so we apologize. However, the agreement, the MOA is basically, it starts upon execution of that agreement. Or when the first eligible structure is demolished. Does that answer your question?
So who made the decision to demolish the concession stand?
That's a good question.
Very good.
There was no directive to demolish the concession stand. There was, however, a directive to our contractor to clear some of the trees along Highway 120.
There was
What does a concession stand have to do with trees?
What I'm saying is that during that clearing operation, the contractor made a mistake, and we take responsibility for it, but that was.
The tree line is nowhere near that concession stand. The tree line is nowhere near that.
Yeah, exactly. The tree lines are really. What about the water and power?
There are demolition permits that can be pulled, but they're only pulled for the traffic. I believe that there was not, and the code enforcement then went out and
Did nothing.
that has been fixed. As far as I know, that's
Did
code
nothing.
enforcement and building codes.
Did nothing.
Code enforcement issued any fines to realistically for demolishing the concession stand at the racetrack?
I do not believe so.
Do I?
I do not believe so.
So, because code enforcement's findings were what? Adequate,
Inclusive that they,
inclusive,
I think it was inconclusive for what they could see.
so they couldn't, basically what code enforcement was saying is they couldn't prove that the concession stand was torn down.
I mean, they're not here, I don't wanna put words in their mouth.
They can't see pictures from one day to the next when it disappeared all of a
The
sudden.
tractor and
Identify the structure that was demolished.
You said you were gonna find it, so you lied. That's great.
Alright, so, any other questions?
Given your previously stated interest in letting the racetrack go to a buyer if you could find one, and you have everyone come forward with funds, what is it gonna take to get that deal signed? I know we're obviously not in the business of interfering with business, and the success or failure of businesses in the county. However, we are charged with balancing the general welfare and other items that were listed in our objectives by our chair earlier this evening, along with private property rights. I would be very interested to hear what it would take to get this over the finish line, because we are spending a lot of time going in circles on something that sounds like could change tomorrow.
The purchase contract, no different than what I said earlier. And I know there's some anxious people here, but the racetrack cannot be purchased if it doesn't come through us, because I can subdivide off the track and sell it. Kevin Whitaker is not going to do that. He's going to take it by 150 acres if you want it, because he's been telling me that for 3 years. So I know people pursue me to build a building, and that's fine. But I'm actually trying to help you, I'm not trying to hurt you.
You're not helping when you're not acknowledging the issues. You're not helping when you're not acknowledging the issues.
Yeah, but
I didn't say there was anything, but you can't even get Kevin Whitaker to agree and work with you.
Mr. Wilson, you would just direct comments towards the board and not the public. Thank you. Can you finish your statement towards Ms. Massey?
Could you ask the question a little bit louder, please, and a little bit clearer for him?
What it's gonna take to get it over the finish line. I'm just worried
about how much time we're spending going in circles. I don't want to do this again after tonight. If there's a way that we can reach a resolution more easily between you and the seller, it just feels like that would be in the better interest of everyone, besides going in circles over things here.
Well, he's not, so she's asking us. So you're asking us, let's be clear, what's it gonna take to resolve the contract between Mr. Manley and Realty Link? That's the question, right? So,
That's the two things I mentioned.
so there's two things he mentioned earlier.
One that I know that is to be struck through and changed. And the other one can be deleted or clarified. And then I got two contracts here tonight. We can sign them right now.
And how can we entertain moving forward with that? Because that sounds a whole lot better to everyone in this room.
Okay, tell Mr. Manley to stand up there and put the
Where's he
contract there and sign it, and Mr. Wilson to sign it, and that contract will be signed.
How about,
We can
but
vote
that's
right
not
now.
safe to,
It's supposed to be changed first.
It's already changed, ma'am, excuse me.
No, it hasn't.
It's changed as the way Mr. Manley has suggested. If you have, we can redline it, and we can redline and make that change in a.
Yeah, bring the contract up there and we'll discuss it in front of everybody. Bring the contract up there and I'll pull out the 6 points.
Let's do it. Let's all hear it.
We're talking to you, we're not. So are you asking us to do this, Madam Chair?
No, what we're not giving is an employment contract, so planning commission meeting, that's just weird.
This is out there, I'm pissed with the best of them.
Here's an issue. You have a good faith agreement and negotiation going on with parcel. Okay, whether that was resolved today or it'll be resolved tomorrow, that's between both private parties. From a planning commission perspective, my answer on phase 4 tonight is going to be a no. Because you have interested parties negotiating a contract. I do not feel comfortable giving you land use for something that if you sign a contract on tomorrow, you're gonna have to come back before us anyway and change all over again. And that's just where I stand on the issue. I have issues with this that you provided us. I don't understand why you guys didn't try harder to preserve such a historical landmark. However, that's not tied to our land use issues. Our land use issues are tied to the site plan issues I have with your easements, the traffic compliance issues we have with the traffic study, and a couple other factors that are tied to section 12 that give us the authority to protect the interests of our citizens. You don't have a terrible plan here. I understand what you're trying to do for Pickens County. However, you have so many moving parts, and you're asking us to approve a really, really large project, and you couldn't even bring me a traffic study that was in compliance with what I've asked you guys to bring back to us. Sorry, that's just where I'm at with it tonight. If things change, great, I would love for you guys to come back. I would be more comfortable with you guys withdrawing your entire application tonight, if that's something you would consider, instead of taking a no. But that is up to you guys. However, you are negotiating a contract. They can't withdraw, we have to say.
So, the time for withdrawal is at the beginning of their public hearing, where they can say, I would like to withdraw it. We've already been discussing it,
Okay, well
so.
then, I'm sorry, then I'll take back my withdrawal statement.
May I ask you a procedural question? And I know we tabled it at the last meeting, but there's the traffic study deficiency. There was a concern you had about the easement and the buffer zone. Is it possible to keep this ball moving in one way or another under 1205E3C, to table it to the next meeting or a time within which you say you can do the 2-mile study, which apparently was a time constraint from the last meeting, so we can sort of narrow the issues down to what's left and then make a decision on the merits, whether we think it should be approved or unapproved?
We have to take action tonight, this is the
Yes.
60 days. Okay.
It, well,
I
it was
understand
tabled,
the
it
withdrawal
was
part, but I
tabled to
understand
be
that.
taken up at the next scheduled meeting. This is the next scheduled meeting.
So we can't table, we can.
Right. I think if I understood correctly, correct me if I'm wrong, the suggestion was that a conditional approval related to the traffic studies that you were suggesting, or you were suggesting?
Well, not really. We need the traffic study to have all the elements to decide whether or not we should approve it or not approve it, as opposed to conditional approval. Once we have all the elements and what's necessary for the decision, then we can make a decision, I believe. Madam Chair, I think that's how it works. And I'm just looking at 1205E3C, and I'm trying to figure out where it precludes a further tabling.
I'm told that we have a 60-day after. We have to take final action within 60 days after submission.
Okay. Even if it's with the consent of the applicant for the extension?
That is the requirement of the 60 days consent of the applicant would be considered
Okay.
at their expense and ours, essentially. Yes.
Well, we have to take action on that, and that's where I stand on the item.
So I'm looking at this, I see the size of the project, the location, Highway 123, 124, volume of traffic that flows through those two roadways, and the fact that the study is not deficient in one way, it's actually deficient in 2 ways. We're supposed to have a 2-mile study, we're also supposed to have a 20-year timeline on it. And so considering those two things, with the size of the project and the volume of traffic on the highways that are directly adjacent, it seems to me that we need to have that document complete and properly executed in order to make a decision on this.
Anybody else?
I agree with that, especially in light of the other traffic studies we have seen very recently where all of the intersections area failed miserably. To put it that way.
Any other discussions? Are you looking for a question?
No, I was just looking at the traffic study policy.
Jennifer, anything else, or you good?
I think, I made my stance clear at the very beginning of the meeting, a lot more information, including the traffic study, would be needed in order to ensure that we are in alignment with land use.
Okay. So let's go back to our, on this topic tonight, procedure. So technically, what motion do we have on the table now? We combined 3 and 4 for discussion, but we need to vote on those individually.
There's no motion currently.
There's
draft report needs to reflect that. So a more accurate reflection of what the county, what our experts believe, is the comprehensive plan, a more accurate.
Could you clarify? I'm sorry, I think the chair had mentioned the Greenville water.
The rewater easement that we discussed.
That's resolved.
I think I have a better understanding of that now, yes. And, you know, with regard to, we have a good faith discussion on the contract we negotiated currently. There is a possibility that this entire project changes tomorrow. However, not tied directly to land use, but is somewhat important to the discussion. Any other comments? Okay, so we have a withdrawal motion. So now we need to make a motion for each application. I'm going in the right direction here. Before I start saying things, please. Okay.
Did the applicant say they would withdraw?
They cannot withdraw.
I'm sorry, okay, I'm sorry.
I didn't understand that tonight either. I thought
Yeah.
there was an opportunity for them to do so, but no, because we did table, we do have to take action. So my new proposed motion is going to be to deny phase 3 with retrospect that the applicant come back before us with either a negotiated contract, the new site plan, the traffic study that reflects our traffic study policy with the 20-year horizon and the 2-mile study, and Jennifer's answer to her comprehensive plan questions.
Is that what?
Is there a time on that, Madam Chair?
No, you guys, from my understanding, have any available time starting to our next meeting to reapply. So you could come back as early as next month.
The application deadline's already passed.
Oh, I'm sorry, okay, so the following month.
Is there a time frame on the contract to be negotiated? I mean, when can that be?
I can't,
Right.
I mean, that sounds like again, a private party agreement. My
Yeah, but you're
concern-
making, Madam Chair, you're making it stipulate
I'm
stipulating that.
not, I'm saying that that's not a part of our land use decision tonight. The contract does not apply to our denial, or my motion for denial tonight. My motion for denial ties to the traffic study policy
Right.
and
That
Jennifer's
needs- that
questions
needs-
about the comprehensive plan.
That needs to add, just add the 2 mile.
You have a, yes, on our
2
traffic
miles
study
and 20
policy.
years. Right, 2 miles and 20 years. I'd like to make sure that's clear, so we're clear when we read the meeting minutes, that we follow your directive.
It's in the.
Because I get it, but I wanna make sure we're clear as a body, that we understand what Madam Chair's denying us on. Since I'm making a motion on denying, so we need to be clear on that, right? Is that fair?
Yes.
Okay. All right, and then,
One more question. When you say to bring it back to have an executed contract, can we say substantially as it exists today? Because otherwise, I'm at a very weak position. If Jackie looks not like that guy, I think he's a good guy, an honest guy. But he could just simply say, I'll give you $1 for it, you will never go back until you sign my contract.
Mr. Wilson, I understand that, but it sounds like you guys are just picking apart very fine details from what you've explained to us tonight. And again, I don't want to get into a private party agreement about your negotiations on the racetrack. However, from what you're explaining to me tonight, there are good faith efforts that a negotiation is happening, and that can change your site plan. That does not hold any effect to my motion on denial tonight. It is strictly tied to the traffic study and Jennifer's questions about the comprehensive plan.
I thought
What you guys
if we
do,
came back with a new application, those conditions had to be met to come back.
That wasn't in the motion.
That was my question, are you making a conditional denial?
no, for, because they're asking us why.
Because that is how we have been advised to phrase our denials moving forward, is to list what we deny based on.
I was
What they're talking
I
to.
was just making sure that we capture the motion for denial.
Right. Right.
That's all, that's all.
Thank you.
As it relates to your contract negotiation, I mean, based on this discussion tonight, it seems like when you come back, you either should have an executed contract or the negotiations have been abandoned and are proceeding. In which case, your initial plan that you previously submitted would be what would be processed. Or alternatively, it would be the revised plan reflecting the sale for this gentleman over here.
It's gonna be one or the other.
Thank you, Ron.
So you fulfill the requirements for the submittal, right now the submittal is incomplete because of the problem with the traffic study. So if those requirements are fulfilled and we come back, then we're gonna look at it in that context. And we're gonna be looking to make a decision based on that. So we got a complete application and all vote on that and approve or deny in that basis.
And right now, the only problem is the traffic study for the night. Is that correct?
And the commissioner has also raised the issue of,
Inconsistency with the comprehensive plan.
comprehensive plan.
Because from a county perspective, from where I'm sitting now today, our county staff report is saying one thing that lends itself to a denial versus what the conversations have been for months on. So from a litigation standpoint, if the county were to go to litigation, a group could say, well, you said it was against the comprehensive plan. So I am asking if there's a reapplication that we need very clear advice and direction and on record, recorded from our staff, that it does meet the comprehensive plan and how. Because it appears that we've had some discussions, and point that out. That is for protection of the county now, and in this case, and setting precedent. That's why I'm asking.
Yeah, and that's an internal situation, that's not.
That's correct.
So,
But that's why
But we-
I'm denying.
I get it, but we can't solve that.
No, but what you can do is when you do your application and it says, you guys put, is it, compliant with the comprehensive plan?
Yeah.
You guys can say, yes,
Thank you.
because. Thank you.
Yes, ma'am.
I think it's important to say, as I understand it, Madam Chair, the reason we're denying it is because the application is incomplete due to the lack of the required traffic study. It's not to say there are other issues with respect to the proposal that might result in its disapproval, but we are reaching those because we don't have a complete application per se.
Strongly suggest that if we have other concerns related specifically to the historical preservation aspect or something like that, that they be included in the motion for reject. Don't want to say anything that's been addressed when it's been addressed.
It has been, we discussed it. My questions were answered.
I think the only protection for historical, from my standpoint, my concerns would be for them. Demolition of that track next to that body of water, that's gonna be a pretty penny to do it properly and legally. So that's my only concern.
Thank you for your concern.
So, Madam Chair, do we need a motion?
I've already made the motion, correct?
Yes, you have.
There's a motion,
There's a
there's no
motion on the
second.
floor.
I'll second.
And that motion is clear for y'all, or not?
Would you like us to read it?
can you read it?
Well, there's no way to just a motion to deny.
No, you're not, but we're just on, I don't understand why you're denying, you're being clear.
Your traffic study, 2 mile.
Do you have any questions, Mr. Stan?
No, thank you.
Or-
Yes, ma'am.
I have a question about the traffic study. So 2 mile radius from the project, and the intersection of the road.
I want you to take the then what generates a 1,250 trip per day study
We'll give us that.
is what I want as a traffic study. And that's gonna help us better understand the intersections in a 2-mile radius. Because that is the issue that we have on 123, is we've already seen several other traffic studies where intersections in that 2-mile radius fail. So therefore, we need to see for your traffic study, A, what it says, what we need to review, and are there any additional approvals that we need to make with that traffic study to address those traffic concerns? And I don't have that in front of me tonight. I only have the intersections that directly affect your project. Does that make a little bit more sense?
Have you seen the policy? Okay, so you're familiar with it, you know where to find it. So you can review the
I'll send it.
requirements and then proceed with your study and meet those requirements.
Send the contract back to
Madam Chair, before we vote, can Cindy read back the motion? I sort of lost track.
It's only a motion to deny. You cannot.
Oh, I thought we had,
There are no conditions to a denial.
oh, I thought.
I was just stipulating why I'm making a motion to deny the application. Our attorney has been very specific with us that we need to tie in the elements of the UDSO to why we would deny an application, which is why I went down the rabbit hole of explaining how these tie to our public highway UDSO for a denial.
The motion doesn't have to include the
Not the motion itself.
Okay.
But for the record,
Gotcha. No, I understand that.
okay, so we have a motion. Do we have a second? I can't remember.
Jennifer, second.
Great. All those in favor of denying phase 3? Raise your hand. Action item phase 4. Make a motion to deny phase 4. Second. All those in favor of denying phase 4? Aye. Moving on to phase 5, I would like to make a motion to deny phase 5. All those in favor of denying phase 5? Thank you, gentlemen. That was not easy to sit through. I appreciate your patience and working with Pickens County. I understand we're wanting to get this project to the finish line, but I've got to see all the moving parts. And I understand that we have negotiations on the Speedway traffic stop, but you gotta give me some sort of ending there. It's not comfortable giving land use for something that's in negotiations to change at any moment. So when you guys come back, which you know you will, we want a concrete decision made on if the track has been sold and what your site plan looks like. And I appreciate you, and I'm sorry that you've been applauded out of here within them, that it's not easy. I understand their perspective, and I understand your perspective, and I thank you for being here tonight.
And I appreciate that. I really thought we would have a good compromise on that. But, Monday night, so we'll see where it goes.
Thank you, Mr. Wilson. Okay. All right, moving on from our applications tonight. Do we have any new business to discuss?
No, no.
We already discussed that there's nothing on next month's agenda.
requirements for county level, site plans, for solar farm locations, so I suggest with Toronto generative that when we get together next, we'll look at those minimum site plan requirements and see if there's anything we need to do at county level to augment that, or if we can make sure it's specific enough. About 6 ways, so it's not particularly specific, but it was we want to assume the state is licensed to do it, simply the district wants to use what they have, we don't have anything else. So, I think I would say communication with council, we do have standards at the state level now, and we can actually, from the data center side of things, there's some state legislation as well, to implement some research on some of these.
Yeah, there's bills, working through, right now, essentially putting a statewide moratorium on data centers until 2028. There was an instance in Spartanburg, they were real close to approving, a data center, and their representatives within the county came and did a town hall type thing. I watched the entire thing, live, and essentially Columbia is saying, we are asking all counties not to approve any data centers, because as a state, we need to look at all of us as a whole. Because a data center in one county doesn't just affect that one county for a wide variety of reasons. So it looks like, maybe, perhaps, the state is just kind of trying to get themselves together, and there's gonna be a statewide, possibly moratorium until further notice.
So, regardless of action at the state level, my intent on data center landowners would be to ask for some guidance from probably SCS or ACOG or whoever we can find related to whether we treat those as permitted rules with some sort of periodic review, since the impacts are currently difficult to assess. And then things like utility rates, which we are not generally in the business of doing, some site plans and things like that. So, most of the impacts that we're finding in just generally available literature were utility rates, water consumption, disposal of assets, and then there are no effects there in noise, specifically with frequency. None of which really typically fall under things that we require for site plans. So I would try to move forward with some kind of stopgap things that we can put in the EDSO for site plans that would include, hey, your site plan submission has to have these things considered. And then my proposal would be to continue to work with some folks that could give us some legislative advice as to whether or not we can treat this permit.
And you'll have those conversations with.
Yes, I mean, I will work through staff to see if we can get some of that advice.
Great. Alright, so we've got solar farms and data centers updated. You're working with both Trip and Jennifer on that now. Okay. Hotels and lodging is next. Jennifer and Jessica. Updates on hotels and lodging.
The first round of just rough draft hotel ordinances for Pickens County to adopt are done and finished. And I would be happy to put them for all of us to discuss. Jessica helped put some of those together. I put some of those together, and I based them, started at the state. So minimum requirements at the state, and then added some Pickens County flair to it. So if you want me to bring all of that or submit that to Sydney and TRAG for discussion for the next month,